So what's on this slide here is a list of issues and the relevant standards of review at the Federal Circuit for those issues. Patentability issues for amended claims at the Federal Circuit are essentially the same as they would be for original claims. So, you've still got substantial evidence review for factual issues. That's generally a very deferential standard of review. You also have de novo review for legal issues, including claim construction. That's where the Federal Circuit can take a look at the legal conclusions the board has drawn de novo. And one sort of last point on, whether the board should have reached a ground sua sponte. This comes out of the Hunting Titan Federal Circuit case that Jessica discussed earlier. That's considered, that's reviewed as whether the board applied its own procedural regulations properly. That's reviewed for abuse of discretion, also a fairly deferential standard. One of the things you can see from this chart is that while there are many issues reviewed de novo because they're principally legal issues, a lot of the bread and butter issues that you're going to face in IPR, namely anticipation and obviousness, are principally reviewed for substantial evidence. And a big one also that comes up a lot in motion to amend practice is written description and new matter. The new matter, the patent owner has the burden to show that the proposed amended claims don't contain new matter, and for that they essentially have the burden of showing that the original specification, original application, and the originals of any parent applications in the priority chain provide adequate written description. That's reviewed as a factual issue. The key takeaway here is that if you do not prevail on a written description or new matter issue as a patent owner at the Patent Trial and Appeal Board, you have an uphill battle awaiting you at the Federal Circuit because substantial evidence, again, very deferential standard. The court essentially says, could a reasonable mind have come out the same way the board did, presented with the evidence that the board considered? And as you can imagine, fairly deferential standard. You also have motions to amend subject to review under the Administrative Procedure Act. This simply ensures that all parties involved had adequate notice and were appropriate to submit rebuttal evidence or evidence in support of their positions generally. This comes up a little bit less often now that preliminary guidance is available and there's much more notice of issues than there used to be, but this is also part of the notion that when the board does something sua sponte, it has to give parties notice and an opportunity to respond.